longer seeking a levy, it just seems odd that you say that there's some jurisdiction left to still say something about the considerations that the statute says you're supposed to look at in making that determination.
So, Justice Jackson, a couple of points in response to that. One, I don't ascribe much significance to the singular determination, given the Dictionary Act, that singular can also means plural. But even with respect to this determination, if you look at what the determination was in this case, the initial determination at Cert Appendix 62A, it talks about how the appeals office reviewed both the tax payment transfer request and the request for penalty abatement.
But how about we look at it as it exists in the statute? I mean, I appreciate that determination can be plural, but it says the determination, such determination. There's nothing about that suggests that the appeals officer is vested with the authority to make more than one determination.
There's also nothing in D1, which doesn't mention a levy, in C3B, which doesn't mention a levy, in C3B, which doesn't mention a levy, in C2B, which doesn't mention a levy, and in C2A, which distinguishes, it uses the disjunctive or to distinguish between issues relating to the unpaid tax or the proposed levy. And so in these key provisions in C and D, Congress didn't use the levy language.
Can I just ask you one final question and then I'm done? Why is it gamesmanship for the IRS to get rid of the terribly punitive and coercive levy mechanism in the context of this particular case or any case? I mean, I understand you're saying, oh, that's sort of gamesmanship, but really the only reason why people are getting notice and a hearing is because everybody recognizes that a levy is a really big deal. So when the agency says we're not going to do a levy anymore, it seems strange to me that that's considered like a bad thing.
So the gamesmanship or the potential abuse comes from letting the IRS, on the one hand, begin this process with a levy, and then 10 plus years later, pull the rug out from under the taxpayer, force them to start again in a refund action, and potentially do so, again, using the government's sole discretion about whether to apply an offset, do so after they've lost a determination before the appeals office in order to moot out, on the government's view, the tax court appeal.
Keep going.
That's not what Congress contemplated in 6330 when it pegged tax court jurisdiction not to a continuing levy, which again, it could have said. It obviously knew how to use the word levy throughout the statute, but it didn't in D1 when it just talked about the determination.
Just want to make sure you've addressed 6532 relating to other suits in E1 that Ms. Ross raised.
Yeah, so a couple of points on E1 and on that argument. One, the limitations argument that Ms. Ross made could easily cut in exactly the opposite direction. Congress could have thought that the reason it was staying the limitations period for a refund action was to avoid the need for taxpayers to file a protective and duplicative action because a Section 6330 action might resolve the liability and tax issues. There's no need to run to federal court at the same time that the 6330 proceeding is pending. In addition to that, as Ms. Ross's colloquies with the court showed, that tolling in E1 doesn't protect taxpayers in all circumstances because it doesn't absolve the taxpayer of having to file the administrative refund claim within that 2-year time period. And in fact, here there are a couple of years for which Ms. Zuch can't recover in the refund action because she didn't file the timely administrative refund claim. So the limitations provision that Ms. Ross pointed to in E1 doesn't solve this problem, and if anything, points in our favor.
Thank you.
So the statutory argument here is ultimately quite simple. C2A talks about any issue relevant to an unpaid tax or proposed levy. C2B talks about underlying liability. C3 makes those issues part of the determination, and D1 hinges tax court jurisdiction on a petition for review of the determination. Once the tax court has that jurisdiction, it has under D1 the authority to act that is read against background principles of appellate review. It's similar to APA 706 principles. The tax court can hold unlawful or set aside agency findings and conclusions. It can vacate the appeals officer's determinations about the unpaid tax and liability issues. The other analogy I would draw here, it's similar to interlocutory appeal under 1292B, or to review of remand orders under 1447D, Once there is jurisdiction over an order, which is analogous to the determination here, that appellate jurisdiction also includes issues that are fairly included within the order, and here fairly included within the determination. With respect to mootness, there remains a live disputed issue about unpaid liability and unpaid tax. Ms. Zuch was injured by the misallocation of her money by the IRS. That injury is obviously traceable to the IRS, and it's redressable by a favorable ruling because presumably the IRS will comply and will either credit Ms. Zuch in a future year or refund her money if a court were to hold that she was entitled to that. In terms of empirical numbers, the government has not come forward with any statistics to show that the sky will fall if the court affirms the Third Circuit's ruling and rules in our favor here. There is a recent report from the IRS Taxpayer Advocate showing that between 2004 and 2018, only a little over 1% of levy notices actually resulted in a CDP hearing being sought. Less than 1% then resulted in a tax court proceeding, and the government has not come forward with other examples of where cases like this are being mooted out. And so the sky's not going to fall, and the tax court's not going to have an overwhelming burden if the court rules in our favor. Ruling in the I'm sorry?
There are two other circuits who have ruled against this position. The Third Circuit was saying it wasn't going to follow the D.C. or Fourth Circuit, correct?
Correct.
So the issue has arisen at least two times, and two other courts have said no.
Sure. So it's come up, as far as we can tell, a total of 3 times over the course of decades. My point is the sky's not going to fall. The tax court's not going to be overburdened by our position. Taxpayers in Ms. Zuch's position will be burdened, and I think Congress's purpose would be undermined by a ruling in the government's favor. Again, the IRS began this process with a levy. It shouldn't be allowed to pull the rug out from under taxpayers. Congress wanted to make tax court an available forum. It is a much more taxpayer-friendly forum than district court, particularly for low-income taxpayers. The Center for Taxpayer Rights brief at pages 18 to 19 describes that, and the limitations problems for taxpayers in these sorts of situations.
I guess that cuts both ways, though, because if it happened all the time, I think there'd be a stronger sense that, well, Congress wouldn't have wanted all these cases, the unfairness that you point out, to be yanked around like this, where if it's happening very rarely, you might think Congress wouldn't have thought about it.
Well, but I think the real backstop here is that Congress said that you can't bring an underlying liability challenge in a 6330 action if you had a prior opportunity to bring that liability challenge. And so I would think in a typical case, you're going to have a deficiency notice, and that's going to be the opportunity to challenge the underlying liability. It simply doesn't come up that much that these issues are resolved in 6330 proceedings, but where they are, Congress meant to provide a meaningful forum. And just to complete the point for Justice Sotomayor, yes, there are 2 cases over decades, but in those cases, the government gave up not only on the levy, but also on liability, as we pointed out in our brief in opposition to cert. And so this is a highly unusual, as far as I can tell, unprecedented case where the government has given up on the levy, but is still keeping the taxpayers' money. And that, Justice Gorsuch, to your point, is why this determination still has significance. The determination is what is justifying the government keeping Ms. Zuch's money.
Just out of curiosity, does Ms. Zuch's tax liability for 2014 and 2015 have anything to do with the issues in this case?
It does insofar as those...
She's not seeking a refund for those years, right?
Well, she is seeking a refund insofar as the government, the IRS, has offset her earlier liability with overpayments for those years, and we're saying that that's improper.
For those 2 years?
Correct. The court has no further questions.
Plenty of time.
Right, yeah.
I'm sorry, in answer to Justice Alito, we're only talking about the refund for those 2 years that were credited against her liability, or something else was credited?
No, so there were several years of overpayments that the IRS offset against the earlier liability. And she's seeking to have the earlier liability erased because the $50,000 from 2010 and 2011, I think it was, should have been credited to her, but also to get those overpayments back that were used in order to improperly offset the earlier.
So she's looking for refunds
Correct.
from those overpayments?
Correct.
Okay, thank you.
Can you explain to me just one more time the statute of limitations problem that you see arising from the government's position?
Sure. So under the government's position, 6330E1 does not toll the time for filing an administrative refund claim, which is a prerequisite to then bringing a refund claim in federal
And you'd
court.
have no notice that you need to file a refund claim until there's a determination, until they pull the switcheroo on the levy.
Correct.
And it's too late.
Correct.
Yeah. Okay. And then just curious, do you think Article 3 mootness principles apply in an executive tribunal like the tax court?
Not to avoid the question, but I don't think you need to decide it.
I understand. I understand. You're a smart lawyer in front of me, and I've got a chance to ask you the question. And my colleagues are being very patient. So, briefly, thoughts?
So I think as a practical matter, it makes sense to think that Article 3 mootness principles do apply, because the way this case would proceed, it's going to go from the appeals office to the tax court and then up to the Third Circuit. And then we get to the Third Circuit is going to apply Article 3 principles. So it doesn't make a whole lot of sense for the case to proceed all the way up to that point without regard for Article 3, only for the Third Circuit to then throw up its hands and say, nothing we can do because Article 3 doesn't apply.
Thank you.
So the tax court does apply those principles, and I think it makes sense.
Thank you.
Thank you, counsel.
Thank you.
Rebuttal, Ms. Ross?
Thank you, Mr. Chief Justice. I hope to make just three, hopefully, quick points. The first is that my friend spoke a lot about review jurisdiction under 6330D1, and that being similar to sort of APA review. I think that's not the right way to think about this case. Again, the tax court needs very specific authorization to provide any type of relief. And so if you look at footnote 4 of our brief, we discussed the fact that there's no overpayment jurisdiction here. I think what respondent is really asking for is something that looks like overpayment jurisdiction when Congress has wanted the tax court to have the authority to calculate someone's overpayment, and in fact to say, you, Commissioner, need to go back and give that money to the taxpayer. It has specifically provided for that. So I would point the court to the Green-Thapedi case that's cited in footnote 4 of our brief. Section 6512B does this in deficiency actions. I think it's really important that there's not just sort of free-floating general review jurisdiction in the tax court. The second point I would make on gamesmanship, Justice Jackson, I think you're exactly right. I don't think it's correct to think about, in the D.C. Circuit's words, in Wilson, the taxpayer getting exactly what she wanted when she came into the refund suit, meaning for the levy to go away. I don't think it's right for that to think about that as gamesmanship of any sort. I think here the IRS used the tools that Congress gave it to have this debt go away without having to finally carry out a levy on respondents' property. I think this relates a little bit, Justice Gorsuch, to your question about Section 6532. I don't think it's correct to say that the taxpayer would not have been on notice that she needed to file an administrative refund claim unless and until the levy went away. She would always need to file that, again, because most taxpayers are never going to wind up in a levy proceeding, and so from the beginning, they are supposed to file an administrative refund claim if they think that they are due a refund. The third point, there was some suggestion that there are some provisions in the statute that don't speak specifically about levies. I think they use collection action or unpaid tax. We've already spoken about unpaid tax today. I really hesitate to further complicate this case, but I think the reason why the language is broader in some places is that 6320, which is a statute that we cite in our brief, applies the 6330 procedures when the government has filed a notice of a federal tax lien, and so that's why we're talking about collection actions a little bit more broadly. I don't think anything in there suggests, as I took my friend to suggest, that doesn't mean that we're focused on a levy when the levy is what's before the court. To take a step back, Section 6330, I think, is dense. It's technical, as we've explored this morning. But I think it plainly provides a prepayment mechanism for review of a challenged levy. In this case, Ms. Zuch has fully paid her 2010 taxes, and there is no longer a levy. Section 6330 is therefore just no longer the right mechanism for her, and we would ask that the court reverse the Court of Appeals' contrary judgment. Thank you.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.